Welcome to our compliance conversations in the midst of COVID-19, brought to you by ILSA and Spot On Insurance. Today we'll be covering producer agreements, part 2.
And it's part 2 because there was so much stuff to cover. I know this week we're going to be covering a different perspective, but it's a pretty interesting topic. Thank you everyone for being here. This is a 1-hour session, no longer than 1 hour. You can put in your questions in the Q&A. And Ted, will you please introduce who our guest panelists are?
Our guest panelists are Joanne Delgado. She doesn't miss a beat. Vice President Education and Compliance at the Surplus Lines Association of California, and Wilma Roscoe, Licensing and Appointments Manager with Insurum, former Principal Officer of Producer Licensing at the Puerto Rico Office of the Insurance Commission. And Larry Shiver, Senior Partner at Squire Patton Boggs, former Principal Officer of the...
So one thing I wanted to say is it's really interesting with Wilma and Joanne, because Joanne is going from the private sector on to becoming a regulator. Congratulations on your new role, which I know you've been there for a couple of months now. And Wilma was a former regulator, and now she's in the private sector. And Larry just continues to just keep us all in check. So thank you guys for being here.
He operates with both sides.
And our ILSA participants.
Our ILSA participants are Russ Foster, General Manager at ILSA, Batman. Christian Masonette, Manager at Spot On Insurance. He's got that
bamboo, flowing bamboo going on.
Yeah. And of course, our moderator and chat manager today is Joyce King, Quality Assurance Administrator.
Yeah. So Joyce, set it up for us. I mean, we learned a lot of stuff last week. It got kind of like everybody was like way into it. Tell us what we expect to learn today.
Sure. So last week we did talk about, the focus was really on the carrier contracts. We got pretty deep into those. So we want to continue our conversation a little bit with carrier contracts, and then we're going to move into the individual and agency contracts, as well as we're going to touch some on contracts with wholesalers. Some of the standard components that seem to be common throughout each of these contracts, or 2 out of 3 contracts, are who controls the expiration or owns the business. We'll get into that. The requirement for E&O. All the contracts have some sort of indemnity clause, confidentiality or non-disclosure agreements, non-compete or non-exclusivity agreement, and then we are going to spend some time at the very end talking about governing law and venue. So I'm most excited about that because I can talk about that a little bit. I don't know anything about this other stuff. I'm here to learn on the other things. So therefore we have our wonderful panelists, so I'm so happy you're here.
Awesome. Very good. And for all of you that are attending and are new, you can always send any questions that you might have that you think of during the week. You can send those to ccquestions@ilsainc.com, and we'll address those during the next session. So start us off, Joyce.
All right. Well, so I do want to lead off with carrier contracts. Like I said, just kind of tie into what we talked about last week. This is all from the producer perspective, and I didn't even realize, and I've been doing this compliance for 15, 16 years with you guys. I did not realize how interchangeable the term producer is in the industry. When I say producer, I'm literally just thinking individuals, mostly, you know. I know there are producer licenses and agent licenses, but when reading through some of these contracts, I'm like, oh, they're talking about the business entity. Oh, they're talking about the individual. So I see how much we use the term producer in the industry. For carrier contracts, and I'm just going to put this question out to whomever, in my research while reading through a carrier, I didn't read the whole thing, by the way. I mean, I was literally bored the first 5 or 6 lines, and I was like, I can't do this. This is
That's
just
Larry's job, is to read through those things.
And God bless you. I'm glad there are people like you that do that.
Nothing more exciting than reading an insurance contract.
So what I have noticed is that it looks to me, just based on the ones that I looked through, that carriers can change the commission base at will with little to no advance warning, and unless mandated by a particular state's law, there is no floor or minimum. And I just want to know, is that pretty common? Does that happen a lot? What do you think? What do you think, Larry?
To take that, Joanne. How about you?
I mean, I don't know how many contracts you looked at, and if you saw that in a majority of them, that's just market power, where the carrier has the leverage over the producer and could put that kind of clause in there, unless there's some regulatory or legal basis where they can't do that, or they have to put a minimum or a floor. That's just a matter of negotiation power. So, a company would want to take advantage of that because it benefits them.
Okay.
So I would say it's something you see, but not necessarily always something that's exercised. A lot of that is really based on that individual relationship and how much that producer produces, so to speak. That's going to drive whether or not there's going to be drastic changes in commission or structure.
And that's where my question was, how common do you see this happen? If there's a producer that's meeting all the production, exceeding the production requirements, and then one day, all of a sudden, can the carrier just drop the commission on them? But you're saying that's not common.
I mean, Jay is saying that it happens with some frequency.
Absolutely, it happens.
And I have no reason to doubt that. It just, on a practical basis, if things are going really, really well and you're producing a lot of business and the carrier all of a sudden changes the commission base to hurt the producer, I mean, they're gonna lose the relationship. And I mean, why would you do that? You're biting the hand that feeds you. I think where this gets exercised is where things aren't going well.
Yeah, I was going to say, I think it's market driven. And so on programs or products where a carrier might be one of the only carriers to write it, then they can play with those numbers and exercise those pieces of the contract. And sometimes it's going to be claims based as well. Right. So if the product is not doing well, or they want to see more or push away from it, they're going to make adjustments accordingly to kind of drive the producers.
And Jay's saying it's not to individual producers, it's to producers as a group on some lines of business, and goes both ways.
Yep.
All right. Okay. Let's see, how about monies and premiums that are paid directly to producers should be paid to the carriers on or before the due date of the inception of the policy. Again, I saw this in a couple of them. Or the producer will be liable to pay interest at a rate of, and this is just one example, prime plus 1%. Is that common? Does that happen a lot?
I would say that yes. In
Did they enforce?
Experience, they're looking for those payments to be pretty prompt. Enforceability, I think it depends on the program and how much is getting produced, whether or not there's any flexibility allowed there.
Okay. In that same scenario, what else could go wrong if the premium's not paid on time? And this is just me not knowing anything about it, but I assume that the carrier would not outright cancel the policy because the insured technically paid, or does it not work on the technicality like that?
It's challenging for sure. If a claim comes in and it turns out that the carrier denies the claim because didn't receive the premium and the producer had it, yes, that's a problem for sure, because the producer is keeping monies that he shouldn't have kept. He should have sent it over immediately or as soon as possible to the carrier to pay for that premium.
That's why there's E&O insurance.
Mm-hmm.
I mean, they just had
And we'll get into that.
situation a few weeks ago in California where they arrested an agent. She was accepting all this premium money and paying sometimes partially, and then forging the signatures of the insured.
Oh, yeah.
And she was financing the premiums and just keeping all the money. Joanne, you heard about that story, right?
I've heard it. I've lived it in my prior role. We've had that happen a few times where producers just abscond with millions of dollars before anybody figures it out, and then they leave the country. So there's not a whole lot you can do from the perspective of, I'm going to say the business perspective. You're relying on, I'm going to say coverage to try and, take care of that. But the carrier cannot cancel coverage if the insured, I have also, because of my background on the carrier and broker side, if the carrier tries to cancel the coverage, but the insured has paid the producer, the coverage is in force and fully subject to, being claims and everything else being paid and the policy being serviced. So the producer, so the carriers are serious about making sure that there's a prompt payment schedule. But I do think, again, it depends on the relationship and the length of time, whether or not they extend any flexibility.
Someone explain dedicated fiduciary account for the receipt of premiums, as in, and I read this, cannot be commingled with funds held for use in any other capacity. This would be for producers receiving premiums from insureds.
So I feel bad, but no, yes, that is typical. And it's typical, and it's there to protect both the producer and the carrier. So from that standpoint, the fiduciary, and so we're strictly talking about the producer holding a fiduciary account with those premiums they collect. Okay. Because then there's also state fiduciary account requirements that brokers are also subject to.
Okay.
But for carrier premiums, it usually is set up in a fiduciary account. And then depending on the relationship with the broker, that account is swept for those premiums.
So basically what we're talking about here is agency law. And so because the funds are coming in that belong to the carrier, not to the producer, and the producer gets a commission from the carrier, that's why those funds are being segregated and going into a fiduciary account or a trust account or something where it's protected, so that the funds all go where they're supposed to go. Now, in reality, the producer will technically take out its commission and pass the majority along, usually. It depends on your systems, I guess. But that's why it's set up that way. And it's set up that way, and you all can correct me, but I believe that if there's not statute, there's regulatory requirements for these kinds of accounts between producers and carriers and agents and all those things. And it's because of that relationship. It's an agency relationship. You're acting on behalf of the carrier. It's not your money, and it protects you as a producer to have the funds going in a protected account and a fiduciary account, not commingled with your own assets. Because this way it could be accounted for, everybody could observe it, you could see what's going on. There's going to be a paper trail there. If you putting aside if there's a statute or regulation that you're violating, if you put that aside, having it in that account is just a safer way to do it, so you understand where the money's flowing and how it's flowing. And this way, there's no question of how much money came in, how much money goes to the carrier, what the commission is that stays with the producer.
Okay.
We had something similar happen with us where we had a fiduciary account, and one of the states told us at one point, if we're after a producer and that producer has done whatever wrong they've done, and we're freezing the account, we can freeze that fiduciary account and freeze all your clients.
Yeah.
So that was a really, really scary moment for us. We were like, excuse me? So,
Yeah.
so I don't know how that fits into that, but
Yeah, if a regulator goes in and freezes a producer's account, you know, that, and they have income in there, revenue in there for lots of carriers, that's an issue also. So, I mean, but that's for a whole other thing. Hey, Joyce, before you go on to the next point, I know we have a lot of new attendees, and I just want Russ to share the screen and just show where we have our ILSA newsroom, where we have a lot of the bulletins, well, all of the bulletins that the states put out, because it's a great resource for folks.
Will do. Yeah, if you haven't been on the webinar before, this is a really great resource that we have on our website, ilsainc.com. On our newsroom, our marketing folks keep all the state bulletins up to date all the time. And in fact, you can find stuff here before you can find it on the state website. In fact, there's a couple of ones from Michigan from yesterday there. So that's on our newsroom page. You can tab through here. You can scroll down, or if you're looking for something in particular, either a state or a topic, everything is tagged. You can search for content. So great resource to keep up to date on what the states are doing. Also, if you need to contact the states, on our resource tab, we have all the state regulators' contact information. And by all, I mean all. Let's say that you need to get a hold of somebody in Hawaii. We've got the Department of Insurance contact information. We also have a link to their licensee search, so you can go straight to that from here. The Department of Revenue and the Secretary of State, which also has the business entity search. So you have all of this at your fingertips. This is all free. Anybody can use this. Bookmark it. It's handy. And we will keep it up to date for you so that you can always get the most up-to-date information.
Very good. Thank you, Russ.
We have a question from the chat real quick. This question is, I am a member of SILA, and it seems like several sessions are based on relationships between the carriers and the producers. I get the sense that they're not all that pleasant. Why are these relationships so strained? Do any of our panelists that have been on both sides understand where each side is coming from? Do you have any insight on that?
It's like you're on the hot seat, Joanne.
I mean, I'm going to say, you know, from my experience, generally, I mean, we had good relationships with our producers. So it was not necessarily, I think that, again, it was really limited to certain lines of business and products that, I'm going to say, produced a variety of different levels of claims, where some of that became more strained. And I would say overall, at a surplus line level, it was really, there was a lot of stress and strain from my perspective between the carrier on a homeowner or consumer type basis. And I just think that that market is so competitive, and the carriers really are looking for certain margins, that was really the cause of that strain. But, you know, I'm going to say overall, I would say our general working relationship, you know, was fairly fluid, and, you know, really a back and forth communication. I don't know if anyone else has had any carrier.
I think it would have anything to do, like, you know, carriers are always coming out with new products, and sometimes I know there's pressure to support certain products and market them out in the world. So you think that might have something to do with it?
I definitely think that could, from where I sat, which was really at the brokerage level under a carrier. We worked very closely together on those new products. So for us, it was a different type of relationship. But I think certainly from a broker that's external to a carrier, There can certainly be pressure, production pressure. And I think the production pressure is really the main source of any strain. Even in the relationship that I had where I was running a brokerage that was part of a larger, I'm going to say under a larger carrier.
Mhm.
If you're not going to produce the line, it becomes a problem if the carrier is looking to sit at a certain level within that market or had made plans.
And you're probably going to have producers that have opinions about a particular product.
Oh, definitely not. Never.
From my experience also is the carrier at the end of the day not only wants a projection, but it also has to meet certain certain standards. So the constant training, just watching out for agents doing the right thing is also important. And so yes, carriers are usually very, how should I say, very jealous about what's going on, because at the end of the day, the agent is selling their products. The agent is representing the carrier in the selling, soliciting, and negotiating of insurance products in a certain way. So from my experience, I can also say that yes, carriers are very persistent and very jealous about what's going on with the business. But at the end of the day, if you're doing, you have the right schedule, the right filters on, and you're reaching out for your producers, and it should be a healthy relationship. But yes, the amount of volume that comes in is also very important, because if you have an agency that's not really meeting the numbers, then you have to look somewhere else, because you want to grow your name, you want to grow your company.
Yeah. And you brought up a good point, Wilma, too. It's about the claims as well, right? I mean, you could sell all the business in the world, but if your claims ratio is way too high, then your producers are not finding the right customers, right? So, we're in the insurance business to pay claims, and that's what we're here for, but the claims have to match and be in balance with the production. So that's a really good point that you made.
From a legal perspective, really and I'm going to echo what Wilma said a few minutes ago. The issue is that all the risk, the regulatory risk, the contractual risk to the policyholder, it's all with the insurance company. So insurance companies have the view sometimes that a producer, they're bringing the business in, but they have no risk. Okay, and profit sharing aside for the moment, because that's not a risk, that's extra money. And so when you have all the risk on your side of the equation from a legal perspective, from a contractual and regulatory perspective, and you're not getting cooperation, you're not getting the premiums sent over at the right time, you're not having proper claims communications if the producer is helping with claims, you're not getting if they have certain writing ability, you're not getting the paperwork done on a timely basis, which affects you on a regulatory basis also potentially, and for your annual reporting. That's why there's some tension. But the other point I would raise is that to have a program like this and these kinds of programs where you're talking about issues, if nothing was wrong and there weren't any problems, you would have a 5-minute webinar and there wouldn't be anything to talk about. So the impression that, oh my God, these relationships are terrible, that's not true. Most of them are good, but the things that you have to talk about are the bad facts and the bad acts. And there's a history in this country in insurance disputes with producers and carriers, and some producers in the past, before all the regulatory and legal provisions came to play, ran amok. They put a ton of business on the books, waved their hand goodbye, walked away, and then the loss ratio went to 400%. And they walked away with all the money because they got paid based on volume, not based on what actually happened. So there was that's why in the 80s, in the 70s, in the 80s, and even into the 90s, the regulations and the laws came into play that had all these requirements for producers to protect both sides, but also to normalize this and have everybody understand what was really going on. So it sounds like there's a lot of criticism and a lot of tension, but I don't think that's common. I don't think that's universal. I think it happens. It happens for a wide variety of reasons, but it's happening on these programs because if it didn't happen, you wouldn't have much to talk about.
All right. Thank you for that. I also wanted to mention some of the information that we've received via the chat to the panelists. From Richard, thank you, Sabrina, for your question. You sparked some really good information there from our responses. But from Richard, he says, I suggest that the leadership of an insurance company may be why a relationship is cooperative or not. I work for a great agent advocate insurance company, and I have contracted with uncooperative insurance companies. Money talks, so production or volume will bring the accommodations and favored position of one agency or over another. Profit is critical, as Joanne noted. We had a smaller agency that had an incredible loss ratio over year after year, so we did not pressure them to increase volume since they had great underwriting integrity and they knew what was quality business to add. Profit over premium proved itself in that case.
Well,
Thank you.
That's always the case.
Absolutely. Sabrina says, thank you all for tackling her question. I've got one more subject here under the side of carrier contracts, and just to give you guys a break, I won't ask you this question. I'll let y'all breathe for a minute, and I'll tackle this question because I talk fast, and I should be able to get through it quickly. Although I do talk a lot, so I don't know. It might take a while, but I'm going to try. But anyways, here's my question for you that I'm going to answer for you. Should a producer assume that the appointment process will be a breeze once they are licensed, since the state found them reputable enough to give them a license? And the reason that I'm asking that is really for the benefit of any new producers, new licensees, new licensing managers, or anybody who, heaven forbid, has recently had some sort of background action, even a charge of some kind, or an administrative action. And so the answer to my own question for you guys is no. Don't assume that the appointment process is going to be a breeze just because the state gave you a license. Bless your heart, they gave you a license. I'm happy for you. However, these carriers, they care about who's representing them. They care about who's out there selling their products, and and not that the states don't, they absolutely do. However, I will say that a lot of carriers do a deeper dive on the background, on the criminal history and on the admin actions. And we deal with some clients here at ILSA. There's probably 2 or 3 a year that the state issues them a license, and we go to send the information in for the appointment, and they're denied. And we do an appeal on their behalf, and it's still denied, and there's no way of getting around it. And it's all situational. It all has to do with whatever issue came up. However, again, just to reiterate to new licensees, just because the state gave you a license, do not assume that if you've got anything in your background, don't assume that this is going to be an easy process to get an appointment with the carrier that maybe your agency's already set up with. Did I do okay on that? Do y'all want to expound on that?
You did great. This is a good moment for us to actually show the compliance courses that we have, because we have a whole section that's dedicated to like appointments, how to do appointments. And I know a lot of the people here have staff that actually handle the compliance for their firms. So Christian, if you'll scroll down to the bottom where we kind of show what the courses are. These courses are just about to be launched, but we have agency compliance, and that goes into really good details about the appointments process, and especially what happens. And we talked about this last week during Producer Agreements Part 1. when you change from one agency to another, you have to get the contracts changed over with that new agency, and you have to get appointed, you know, with whoever that agency is doing business with, whatever carriers. So just wanted to show that for everyone that's here. We have a whole suite of compliance courses. Appointments, definitely one of the topics. Thanks, Christian.
I have
Go ahead.
something. I'm going to share something with you guys. I'm going to tell the story without saying who it was. So we had this person, and he was a senior, an older, been in the industry for a time, but he wanted to get appointed or contracted with a particular carrier, and this carrier was very, very strict about background situations. And this man, when he was young, he did something silly. I think it was like in his college year, really, really like 20 or 30 years back. But it was in his record. So he applied, and the carrier said, no way, because there's something there. And he came back and said, hey, I got a pardon from the governor of the state. What are you about? But it was still in his background. The carrier found it. And we went back and forth. The man had to go to, take it off his record, something that happened like 30 years ago. And then the carrier ahead and appointed him.
Wow.
And that's been like the most extreme of cases that I've run into. And it was very interesting how it unfolded. But it happens. It happens. There are some carriers that, yeah, go ahead, write and sell the first policy. I'll look into your background. It varies from one carrier to the next. But yeah, some have very, very high standards. For sure.
We've had some situations on the licensing side where there were some offenses that were even more egregious than that. And I think they got appointed too, didn't they, Joyce? Do you remember?
Yeah. Well, we had,
some did. There's been a few, but prior to my days at ILSA, I worked at the prison. I've seen some of the background checks come through here that would mirror some of the things that we saw at the prison. So,
and we've seen carriers that have said, we don't care that they have those three things. Go ahead for it, appoint them, and go ahead and try to get them licensed, and then we'll deal with the states that won't give them a license.
The common thread seems to be, if you didn't steal money from a client, you're good to go.
Right.
For the most part. And one thing I want to point out on that, and we are going to have to get moving here pretty quickly, but you have to really understand that the question from the state and the question from the carrier is, were you charged? It does not say were you convicted. It says, were you charged with? Okay. So, and we've had lots of clients come in that says that was expunged. That's not on my record. And we say, I'm sorry, it's there somewhere because they found it. We didn't find it, they found it. And they're asking us for additional information. And if we don't come through with it, there's going to be no appointment. We're sure of that. Okay, sorry to rush, but we've got two other subjects to get to. Real quick, Tisha Hill says, my agents always mix up licensing and appointment process. Yes, they do. Hallelujah, that somebody else does our pain. Yeah, they do. We have people come to us all the time. I need to be appointed with so-and-so. Well, what they really just asked me was, I need a license. And then I need an appointment. But, in their mind, it's getting appointed. They don't realize it's a two-step or it's two completely different things. Got to get the license first, then the appointment. Lori, the high standard carriers, I think, have been fined by the state. Ooh.
That's why they're good now.
That's why they're high standard now. Okay, I got you. All right. Hey, let's move on and discuss individual and agency contracts. So the individual producer going to work for a business entity, this is the contract that the agency has signed by that individual producer. Okay. On these individual to agency contracts for the standard, who owns the business at the end of the day? What's that contract going to say, panelists? Is the individual going to own that business, or is that the business entity?
It's usually the business entity. the one that owns it. If it's your employer, right,
Mhm.
I mean, there are a lot of possibilities out there, but if you're going to go work for someone and that someone entity is providing leads, it's providing you the equipment and you're selling, soliciting, and negotiating because you have a license, but you're doing it because of the business entity. Yeah, the business entity has over that business. It's a different story if this is your client and you know you're an independent maybe, but if you're working for someone else, it's a different story.
I think it becomes a little bit tricky, like when you have a high profile producer that it's in a niche and they move to another company and they bring a book of business with them.
Yeah.
It becomes tough situation.
Yeah.
And they might negotiate it as well, like, you know, yeah, let's split, or this is mine, and pay
Okay.
off part of it. Yeah, I've seen negotiations
Okay.
happen too.
For the most part, you would say though that at the end of the day, that business belongs to the business entity, and their having signed the non-compete part of the agreement kind of prevents them from being able to walk away with that business. And is that correct?
Right.
All right. And then non-compete is actually what I have on my list next for y'all to discuss with us. Can you talk to me about the non-compete agreement in regards to geography and time that you're aware of, and then violations that result in payment of any damages to the agency? My questions are how enforceable really is a non-compete agreement? And I know that's state by state, I think. I think that's what you need to answer for me. Are there states that do not recognize non-competes? And then are there states that have been putting limits on non-compete agreements? I'm sorry, that's a lot of questions, but just to get our convo going, how often do I need to review the language of a non-compete? Where can I find information about current laws and regulations for non-compete agreements?
So from a legal perspective, I'm not an employment lawyer, and that's really where this sits. My understanding is non-competes have been more disfavored in the last several years than in the past. There have been quite a few very onerous non-compete agreements that have nothing to do with insurance. It's just the genre itself, which have been unenforceable in many states, but is a state-by-state authority. And a lot of times these are really not enforceable if they're unreasonable. So in other words, if you sign a contract that says you cannot work in the insurance industry if you leave us anywhere in the United States for the next 5 years, I'd find it very, very strange if that could be enforced. But if you have a provision that says, I don't know, pick a jurisdiction. If let's say you're working on Long Island, where I am sitting right now, if it says you can't work in Nassau, Suffolk County, on Long Island, writing a certain line of business for the next 12 months, that might be enforceable. And again, I don't know what the law is off the top of my head, because this is more in the employment law genre than anything else. But I think it's a question of reasonableness, but outrageous requirements that we've seen in the past, they're just not going to hold up. That's my recollection of the area from the legal perspective.
Ooh, all right. Real quick, I'm going to read some comments from the attendees to our panelists. One of our attendees says, we make sure, this goes back to my first question, we make sure that the agreement with our producer employee states that the business is the agency's business. So that's definitely written into the contract.
It's always in there, yeah.
Another person says, just to share some info, in New York, there are broker and agent licenses. That is true. Back in the day, it was fairly standard to issue a broker license if you worked for an independent agent. Many carriers are now mandating individual agents to be appointed in order to get a quote, not just the agency. Since my job is appointing agents with our carriers in our agency, needless to say, my hands are full. You cannot be appointed if you hold a broker's license. That's absolutely correct.
Yeah.
And to go one step further on the New York situation, you can't get a surplus lines license without first holding the broker license. The agent license does you no good.
Yeah. And another good point that Tina wrote was carrier questionnaires can vary and may ask different questions in the license application. So you have to read them very, very carefully and answer them very accurately because they're different.
That's true.
Back to the question about the appointments. Right. Thank you. Compensation, is it typical for individual producer to be compensated on a commission-only basis or base pay plus commissions? Are there all sorts of variances to compensation in these kind of agreements?
Or contingency.
Yeah.
Let's not talk about that.
I mean, so from my perspective, in terms of different ways I've seen it done both ways. Straight commission versus base plus some smaller commission or some smaller percentage of commission. In the surplus line world, I've seen more of the base, and a lower commission to individual brokers. So I guess that would be, just to clarify, I mean, are we looking at carriers to agencies or carriers to individual agents?
Carriers to individual agents.
Yeah. So that's kind of where, on the surplus line side, the agent is, there's not as many individual agents, right? They usually are part of an agency and working under some agency structure. And so I would venture to guess, from an agency to individual agent perspective, it may be commission based, similar to how it would be with an agency.
All righty. Okay, another item for discussion. Let's talk about licenses. Joanne, you and I have had this conversation a couple of times already. Somewhere in this contract between the agency and the individual, and the one that I reviewed did not get into the nuts and bolts of this, but as you and I've discussed, they probably should. The contract should address, how does the licensing work? For example, who's responsible for maintaining the individual's licenses, who acquires the new licenses for the individual, not meaning who goes on and apply, but who's paying for that? Does the individual have to pay for it? Is the agency going to pay for their licensing? And then maybe even more importantly, if the agency is using your licenses, and we're talking about surplus lines licenses at this point for filings and reports. Should you terminate, what is the plan? This should be written in the agreement. This should be hammered out in the beginning, okay? You should know before the time comes that you're walking out the door how your licenses are still going to be used once you're gone. If the agency is to be, if it's your determination that they're to be cut off immediately, or if you're going to allow them to put that final little bit of business on your license, but who's going to handle the reports? And then if you move on to another insurance agency with surplus lines and you're writing more surplus lines business for them, there's going to have to be some really great communication to put these reports together. So Joanne, really I'm just kind of putting that out there for you to expound on. I know you seem to be a little passionate about that subject, and I just want you to share that with everybody.
Yeah, well, I mean, what I would tell you as a broker going to work for an agency, be very careful of the agency agreement you're signing. Make sure that that agency agreement is very specific as to, again, really everything that Joyce just pointed out. So how those licenses are going to be maintained, who's responsible for those costs, and how the transition is going to take place. The other thing to be clear on, and this is just more from like kind of the upfront preparation piece, is that an agency cannot use your license after you leave. So only business conducted while you're an employee of the agency is the only way that they can use your license. So be careful about what you're reading if they say they can keep filing subsequent transactions or using your license, because your license is really, again, that's your business card in the industry. And if there are any errors or issues that cause a problem with your license, you're the one that's going to live with the administrative action that then has to be reported in all your jurisdictions. So I would tell you most agency agreements are not thorough on that basis and in that nature. And we often ran into, and again, I was on the compliance ends of things, and having brokers come back to me after they were either left the company willingly or at will or by termination, so being laid off, and coming back with thousands and thousands of dollars in fines because they didn't really understand that their agreement meant that when they left, those licenses travel with them and become their responsibility. And if you hold a surplus line license, you do have to file 0 returns. So whether or not you're doing business, you owe that in, I don't know, I'm going to say somewhere in the 20 to 25 state range will require some form of 0 return and will fine you for not telling them you didn't produce any business.
Joanne, have you ever seen a situation where a producer left those licenses with the agency to continue using them because maybe there was some financial incentive? They're transitioning on to something else and the agency says, hey, we're going to pay you X amount of dollars to keep these licenses in place for 6 months, 8 months. What happens if something goes south and that producer has to get in front of a regulator and say, I had nothing to do with this?
Well, I hate to tell you, that has to be written into the agreement. So it's really not, there's no way for you to leave one company and have no ties to it, but allow them to use your licenses. It's not legally or acceptable at a regulatory level in any state. So understand that if you're extending your licenses to a company, you are going to be finding somewhere in that agreement in some way, shape, or form that you're also named as still being part of that company in some capacity. So it might be as a director or an officer of the company, but in some way, shape, or form, you must maintain a relationship in order to allow an agency to use your license. And as well, you want to make sure you have the proper indemnification in place.
Exactly.
Yeah. So, Larry, I don't know if you want to talk more about indemnification.
No. I was just going to say exactly what you just said.
Yep. And that indemnification that I cannot say properly, it needs to be lifetime. So it has to outlast that agreement. It's not something that can have a termination date.
So that answers the question of what happens when that licensee gets called before the regulator and may face fines and all of that. That's why you need the indemnity, because you want to take that piece of paper and you want to go like this.
Yeah.
Hold harmless, indemnification, have a nice day, and tell your E&O carrier to wake up.
Start writing our check.
Very good.
And what we do see here, it's very common for a surplus lines broker licensed, maybe not licensed across the nation for surplus lines, to leave, and it's not always an amicable split. In fact, it's probably not common for it to be an amicable split, but you've written business up to the very last day. Some states require that business to be reported on your individual license. It can't be reported on an agency surplus lines license. Maybe it's a state that doesn't issue agency surplus lines licenses. So there's got to be some kind of communication that you maintain with that former employer, no matter how bad it got, because they are the ones who still have those tax monies. They've got to get that paid into the state, and they've got to have your license to report it on. So what Joanne said is they can't use it going forward, and that's true. They can't put new policies on there with effective dates beyond your termination date. But if you wrote something up through the last few days, they still have to get that reported in for you or filed for you, and the taxes paid. Sometimes the taxes aren't paid till the end of the year. Yeah. So you may have to deal with them for quite some time before you can finally cut off that communication with them. And if you're a licensee who never filled out those forms to begin with, or took care of the zero reports, they had a department that handled that. I mean, you're going to be in a pretty bad way all of a sudden, out on your own, not knowing how to and where to complete those particular reports. So.
Yeah, the other piece is really, and I think this is just a gray area, is really what happens when you have business at an old agency in the same calendar year as you do business with a new agency. And how do you combine those reports, and how you share that information with each of those agencies? Because there is what we would consider personal information under different states' privacy laws that should not be privy to both to both agencies that you work for. In addition, it becomes a marketing and competition issue.
Right.
So,
and we've been in the middle of those. As a third-party vendor that completes those filings and those reports. From what I can remember, and I haven't done it in a long time, but from what I can remember, a lot of the states are willing to work with us and let us do two annuals, an annual under this agency and a different annual under the other agency. And it does come back down to the privacy laws that you're referring to is why they allow that.
Yeah. You just want to be careful, just understand what it means before it happens. Because when you don't, it takes you by surprise. You're scrambling at the last minute to try and figure out details that should have been worked out before you started.
Absolutely. Okay, you want to talk about contracts between agencies and wholesalers? We've got 8 minutes left. We're not going to tackle everything. And a lot of it is repetitious. Either it's not repetitious, but it mirrors kind of either the contract between an agency and an individual, or it mirrors maybe a contract between a carrier and the agency, and mostly the carrier and the agency. But it's some of the same components in the agreement. So we said we were going to discuss E&O. I don't know if we got too much into that. In all the contracts that I've read, it's 1 million seems to be the typical amount that I see on most of these contracts. But it does look like the wholesaler contracts do require some sort of E&O coverage. Seems kind of a no-brainer. Remember, I don't know anything about this stuff. I'm learning. Reporting, producers to keep complete records that are open to inspection by the wholesaler upon request, and then the immediate reporting of claims, losses, etc. in writing. Sound right? In writing.
Yeah.
Okay. Y'all expound on this anytime you get ready. I'm just reading from notes. Surplus lines placements, how is it determined this is something I want to know. How is it determined who files the policies and taxes if the producer is also licensed for surplus lines? And obviously the wholesaler would be too. So early in my days of surplus lines tax filings, I had some man called in. I can't remember who it was, but he kept saying last link in the chain. And I was like, what does this even mean? last link in the chain. And I had to go and do a lot of research to try to answer this last link in the chain question, which I don't remember the answer to now. That was years ago. But Joanne, you shook your head. What does that mean? Is that something we can apply to this situation between the agencies maybe that have a surplus lines broker, but they're also working through the wholesaler who's also surplus lines licensed?
Yeah, I mean, in most states, if both the wholesaler and the retailer are surplus line licensed, so if everybody's licensed, there can be an agreement, and it should be a written agreement between the two that specify who's going to do the filing and what the filing responsibilities entail. There are 2 states, California and Texas, that have this last link in the chain law, which of course I tried to figure out for years when I first started, right? So what a weird term. But basically what that means is the producer closest to the insured company is responsible for the surplus line filing. So there's other states that have what I'm going to call, in my opinion, are gray laws that sort of say that, but they can't enforce it. New York being one of those, Pennsylvania being another. Those are off the top of my head. But California and Texas had very specific laws that said that if you placed a business with the carrier, you are the broker. And I can tell you from firsthand experience, Texas is more than willing to enforce that. And they will ask you to unwind the deal and refile it the right way.
Wow.
So the good news is there are regulatory changes that took place, and I apologize for not having that date available, but sometime around, I want to say it was the beginning of 13, but somewhere around 12 or 13, in both California and Texas, we passed some new laws that that basically.
You don't start.
I was just gonna say, this is really good. And I take a break because, of course, I'm starving at 3 o'clock. But no. So with the changes in those laws, both California and Texas actually added a provision that would allow the wholesaler and retailer or the 2 producers to make an agreement. So should both be licensed, there could be a written agreement. The written agreement has to be signed by both parties, has to be wet signatures. There's all kinds of rules around it. But essentially in California, it was amended as part of Section 1774 of the California Insurance Code. And then Texas has it in a bunch of different sections. But essentially what it means is that you can, under Chapter 25, 225 and 981, you can delegate the filing responsibility now, as long as that agreement is in writing, specifically notes those sections of the codes that it refers to, and both parties sign and keep a copy of the form in their records. So it's a little bit of good news because last link in the chain is no longer as stringent as it had been in the past.
That's really good information because I've seen that lots of times where prospective clients would call and say, no, like I want to have the license, and the wholesaler would say, no, we're going to file it, and all of that, all of those issues. That's really good information. Hey, Joyce, can you give us a sneak preview into what we're going to be covering next week?
Next week, I don't have any topics with me. However, the content will be, and this is for the next 2 weeks because we feel like there's enough there to put that into 2 one-hour sessions. We will be covering audits, market conduct, and data calls. So that should be very interesting the next 2 weeks. I'm hoping these 3 will be able to join us for those two webinars. We have a few other panelists we're working on getting lined out for those, at least to be on one or both of those. So exciting stuff. Again, stuff I don't know anything about. We don't do it here at ILSA, so I get to learn a lot. Those are my favorite ones.
I think like from the surplus lines carrier side, when they get those data calls, there's always been this contention, right? Like, you know, we're surplus lines. We shouldn't have to be doing all of these reports and stuff. So it'll be interesting. Joanne, I hope that you'll be able to join us for that one.
We'll definitely try to be there.
Okay, I think I've pretty much covered all that. Now, we've got 1 minute left, and I wanted to spend more time on this, but governing law and venue, and I'm just going to throw this out here. And I want you guys, you panelists, to tell me if I'm overthinking this, okay? Because I tend to do that. Almost all of the various contracts that I've looked at, well, all of them, mention venue, governing law, governing jurisdiction, something to do with where the governing jurisdiction will be. The jurisdiction appears to almost always be, or always be, the domicile of the initiator of the contract. Okay, so if it's carrier contract, it's going to be domicile of the carrier. If it's an agency to individual contract, it's the domicile of the agency, which is usually okay because a lot of times the individuals are in the same jurisdiction. And then if it's the wholesaler to agency contract, it's going to be the domicile of the wholesaler. With this in mind, can we talk real quickly about how important it is, or I think it is, to be corporately qualified in that particular state, the state of domicile where these contracts are coming out of. So in my compliance mind, you know, what I know to be true is that before you can bring suit in a state, and this is not every state, but most states have this law, before you're able to bring suit in a state or defend yourself against suit in a particular state as a business entity, you need to be corporately qualified, or it's also known as a certificate of authority. You get those typically from the Secretary of State. And so, Larry, I'm coming at you first about this. Back me up or tell me I'm crazy. What is it?
Well, there's two different things we're talking about here. Okay. We're talking about a governing law clause that tells you when we're interpreting this insurance agreement or this brokerage agreement, what law applies. You can agree, you meaning the parties, can agree to any law they want. They want the law of Switzerland to apply to interpreting that contract. They could agree to that. They don't have to be licensed in Switzerland. It just means that whoever's going to decide a dispute has to use the law of Switzerland to figure out the dispute. Venue is a different thing. Okay. If there's going to be a dispute, where the dispute is going to be venued or seated is a completely different animal. That's a different clause. Those are two different things and not the same thing. Okay. But to your point, and I'm most familiar with New York with Section 1213 of the insurance law, a party who is bringing a case in New York, an insurance company or an insurance entity bringing a case in New York, has to be licensed or authorized or whitelisted in New York in order to do that. Otherwise, they have to post security or they have to get their butts licensed. Now, if you're a defendant, that's a different animal. You can get dragged into court. But to take advantage of a state's court system, you have to be authorized in that state. Otherwise, in the states that have it, security has to be provided or you have to get yourself authorized. So there's lots of litigation about that. So for sure, it makes sense if you're the main drafter of the contract, it makes sense that you're going to want to use a jurisdiction for the seat of any dispute, the one where you're licensed and you can go ahead and file an action. Have to file an action. Choice of law, you're typically going to use governing. You're typically going to use the law of the state where your principal place of business or your corporate headquarters is, because otherwise, why the hell are you there if you don't like their law? So, but that's not always the case. I mean, there's lots of contracts that have New York governing law, and none of the parties have to do with New York. I mean, there's worldwide international contracts where they have to get New York law experts to go to, wherever in Europe, to go to The Hague and deal with an arbitration because they have New York law as the governing law of the contract, and neither party is in the United States. So those are two different animals, and that's my perspective from the legal side.
Awesome. Thank you.
Well, that's very good. And Joyce, we're running a little bit behind the hour, so we're going to wrap it up. If anyone thinks of any questions, you can send them to ccquestions@ilsainc.com. If you want to hear Joyce's fabulous Southern twang, have a question for Joyce, or you want to get a hold of any of our guest panelists today, you can call 254-729-8002, and you will be able to get your answers to what questions you might have.
Great job, guys. Really, really informative.
Awesome.
Thank
See you next
Fantastic.
week. Have a great rest of the week and be safe.
Thank you all.
Bye-bye. Thank you.
Thank y'all so much.
Bye-bye.